So, top focus this hour is a plea that was taken up on Qutub. The Archaeological Survey of India opposed a plea before a Delhi court seeking restoration of worshipping rights inside the Qutub Minar complex in the national capital, saying the fundamental rights cannot be availed in violation of any status of the land.
So the ASI has said in its affidavit that the alteration of the existing structure is not permissible and submitted that neither Qutub Minar or any of its parts were under worship of any community at the time of the protection of the monument. So clear words that is now being given in its affidavit by the ASI. Harish, if you can tell us the other angles also, because the petitioner here in the case is citing when it comes to the right to worship, and that should be given to them.
Yes, that's right. Very significant arguments coming in from the Saket Court. My colleague Nilashish is reporting the ASI has filed a very significant counter-affidavit in the Qutub complex case. They have said that Qutub is a protected monument as per Ancient Monuments and Archaeological Sites and Remains Act 1958. It's a prohibited area where no construction or reconstruction is allowed. But what is significant, Amita, is that even the ASI has said that Qutub Minar is not a place of worship since it got protection by central government. Qutub Minar or any part of it was not worshipped by any community. And what is important is that ASI says Hindu petitioners' pleas are legally barred and admits that destruction of old temples to build Qutub complex is a matter of historical fact. This is the very same argument raised by the Hindu petitioners and says that destruction of old temples to build complex is a matter of historical fact. Qutub complex is protected. So at that moment, Harishankar Jain, who is the petitioner, says that the prayer is limited, that puja can be offered. There are many cases where monument is under ASI but prayer is allowed. He is citing right to worship at a time when ASI admits that it's a historical fact that several Hindu temples have been demolished to construct a mosque. Remember, the genesis of the case from the very beginning is the admission that there were 27 temples and Qutbuddin Aibak demolished it as a show of Muslim strength. It is admitted position that no prayers were offered there by Muslims and no religious activity took place there. So there are more updates coming in from Nilashish, who says that the court says that the court has not determined whether or not I have a right. The court might say I have no right to worship, but the judicial process must be followed to do at least determine whether I have the right or not. So Harishankar Jain is once again raising the right to worship at a time when ASI is harping on the fact that it's a historical fact that there are several mosques were constructed after demolishing Hindu temples. This is a very, very significant assertion by the ASI today in the Saket Court. And once again, Nilashish has
right. So Harish, what the government agency has clearly said is that this of course comes under the Ministry of Culture. It said that there is no denial of the fact that there are a number of scriptures that are existing within the Qutub Minar complex, but it will be contrary to the existing provisions and law to allow it. That's the statement that has been made by the ASI.
Over.
Juncture, Jain refers to the order which dismissed the initial suit as absolutely erroneous, says it is based on conjecture and surmises that there may be some problem, some undeclared threat. It is absurd and totally uncalled for. So serious exchanges going on in the Saket Court, and now the Jain refers to the order which dismissed this initial suit as absolutely erroneous, says it is based on conjecture and surmises that there may be some problem, some undeclared threat. Absurd and uncalled for. And now the court says Section 3 of the Places of Worship Act says to maintain status quo as it existed. Jain argues that section is not applicable. So the Places of Worship Act 1991 is also being discussed in the Qutub Minar case. It's very, very significant. The court says Section 3 of the Places of Worship Act says to maintain status quo as it existed. Remember, this Section 3 of the Places of Worship Act provides for maintaining status quo of religious structures as it existed on 15th August 1947. So the Saket Court, in a very, very significant statement, says that places of worship is applicable to Qutub Minar. At this juncture, petitioner Harishankar Jain says that section is not applicable because Hindus have been worshipping at that spot, though ASI considers it as a mosque. On certain portions, the Hindus have been worshipping even before 15th August 1947, and therefore this section 3 of Places of Worship Act is not applicable. So just like it was in Ayodhya case, just like in Varanasi Gyanvapi case, now places of worship is being discussed in the Qutub Minar case also. Back to you.
Right, but Harish, further what is being mentioned in the affidavit that there is no provision under the said act where worship can actually be held of any living monument. This is the basic principle of protection and conservation. If not allow starting any new practice in a monument that has been declared and notified as a protected one.
Yes, that's right. Let me read out from the affidavit filed by the Archaeological Survey of India. Yes, as you rightly said, the affidavit, Archaeological Survey of India's affidavit says Qutub Minar is not a place of worship since it got protection by central government. Qutub Minar or any part of it was not worshipped by any community, ASI has told the court. ASI has also informed the court that an image of, at the same time, Archaeological Survey says that an image of Lord Ganesha is found on a lower part of one wall in the complex. A grill has been provided there since 2001 to ensure no one steps on it. Another image of Lord Ganesha is found upside down. However, the same is embedded in the wall and might not be feasible to reset the same. Okay. But at the same time, ASI says that on 15th August,
a lot of developments happening in court, and Harish will keep a tab on what's happening. Do stay on with us because all eyes are also going to be on the Varanasi District Court, hearing the civil suit on the Gyanvapi Mosque Kashi Vishwanath Temple Complex dispute as well. So today at 2 p.m. that verdict is also expected on whether to invite objections on the survey report or conduct hearing on the Order 7 Rule 11 application of the Masjid Committee first.
So while we talk about the Masjid Committee that has argued that the suit is barred under the Places of Worship Act, and the Hindu petitioners have said that the survey report should actually be made public. This is the main contention that they have been citing, with the Muslim side saying that they are seeking a complete dismissal of the petition.
See, primarily the issue is that the Honorable Supreme Court has given a verdict that the issue of maintainability of the petition has to be decided on priority. Apart from that, there are allied issues also. So how the hearing has to proceed further, whether their application of maintainability will be taken up first, and if it will be taken up first, whether the commission report will also be considered along with it. These are certain issues which on which the Honorable Court will decide a procedure of hearing, that how hearing has to proceed further. It's not a judgment in that sense. It's just a procedural day where the Honorable Court will decide as to how the hearing has to proceed further.
माननीय सुप्रीम कोर्ट में जो सुनवाई थी उसके परिप्रेक्ष्य में उन्होंने फाइल जो है लोअर कोर्ट की फाइल, सिविल जज सीनियर डिवीजन की फाइल, उसको ट्रांसफ़र करके माननीय जिला जज के यहाँ सुनवाई के लिए उन्होंने आदेश कर दिया था। तो कल माननीय जिला जज के यहाँ वादी पक्ष के अधिवक्ता और प्रतिवादी पक्ष के अधिवक्ता ने बहस किया। उसमें प्रतिवादी पक्ष, जहाँ तक सुनने में आया कि प्रतिवादी पक्ष के अधिवक्ता का ये बहस था कि जो 1991 का वर्शिप एक्ट का है वो मेंटेनेबल है कि नहीं, जो वादी पक्ष द्वारा जो एप्लीकेशन दी गई है उस पर। तो कल उसी पे बहस हुई है। अब आज माननीय जिला जज का जैसा आदेश आएगा उस हिसाब से कार्रवाई आगे की चलेगी।
आरंभ काल से, अनादिकाल से सनातन परंपरा की वाहिका रही है काशी। अत्यंत प्राचीन नगर रहा है काशी। काशी को कहते हैं काश्यते प्रकाश्यते यासा काशी, जो ज्ञान का पुंज है उसी का नाम काशी है। और इस काशी में मुग़ल आक्रांताओं ने कम से कम आप समझिए कि 4 बार भगवान विश्वेश्वर के मंदिर पर आक्रमण किया। और ये आक्रमण कुतुबुद्दीन ऐबक के आदेश से बनारस के शासन के लिए 1197 में एक अधिकारी नियुक्त किया गया कि वो बनारस में जा कर के जितने भी ऐसे प्रतिष्ठित मंदिर हैं उन मंदिरों को तोड़े। तो मुगल आक्रांताओं ने मूर्ति पूजा हटाने की कोशिश की। उसके बाद अलाउद्दीन खिलजी ने बनारस के मंदिर में तोड़े गए। 14वीं सदी में तुगल शासकों ने जौनपुर और बनारस के तमाम मस्जिदों को उन्होंने भी तोड़ा।
All right, we'll be going across to our guests also, but for a quick live update on the Gyanvapi story that we are focusing from Varanasi, because the matter will be taken up in the court shortly. Briefly, Harish, both sides that have been arguing that the suit is barred under the Places of Worship Act, the Hindu petitioners now have been saying that the survey report should be made public and should be considered, while the masjid side has been arguing that the suit is barred under the Places of Worship Act. A quick update, please.
Yes, that's right. These are the few issues on which the District Judge Varanasi will be ruling on today. Number one, whether the court will be first giving priority to the maintainability issue, or whether, as per the demands of the Hindu side, whether the court commissioner's report will be discussed. Number three, whether the Hindus will get access to the 1,500 photos and 10 hours of video which have been shot by the videographers and photographers who were attached to the Advocate Commissioner. Number four, whether the Hindus will be allowed to worship at the Shivling which had surfaced at the Wazu Khana. Number five, whether the court will agree to deseal part of the Wazu Khana and which the masjid side is demanding. And the court is also expected to lay down a timeline and decide on procedure on how to go about with the hearing, and set a timeline and decide on how much time the lawyers of each side will be getting. So these are some of the issues on which the District Judge Varanasi will be ruling at, is expected to rule at 2 p.m.
Okay, all right. Harish, continue to be with us, because we'll continue coming back to you for the live updates as the court begins the hearing. Advocate Asad Zama as well as author Anurag Naidu also join us in the broadcast. Mr. Asad, all eyes are going to be on the court, because today the court is really going to lay the roadmap of what's expected. It will set a timeline for the Gyanvapi case that has continued for a long time now. What are your expectations?
We all the people, which the law-knowing people, we are watching that at the 2 p.m. what court will decide. It was a very easy case. Every fact will be taken and seen by the court, and we are well defined. The people, we are the senior lawyers, will say only one thing, that the Worship Act 19, which has been passed in the 1991, this come in the bar in it, and no new rule should be passed by the DJ. We all request that. We have given a written in that. The senior lawyers we have discussed, they are saying that they will hopefully are getting a very good version from the DJ court of the Varanasi, and they have fully faith on the judiciary of the Varanasi. And they are saying that the 101% they are fully, that is totally a Wazu Khana, that is not a, you can say, the Shivling. Mostly the people which are mentally prepared that they are looking like a Shivling, that are the viral videos and the fabricated things which are seen on the social media.
But there are exact calculations and measurements that have already been taken. There is videography, comprehensive and detailed one that has been done and has been submitted in court. But Mr. Naidu, will it really sustain? Because as far as the Supreme Court also, when the same Places of Worship Act that Mr. Zama is now pointing at, the Supreme Court said that let the religious character be determined. It does not follow up under the Places of Worship Act.
So absolutely, that's what we are debating. The Supreme Court did agree, that this matter be pursued, but yet they did give some of the directions to the district court, and the district court by all means is following it. There is a videographic evidence which is sealed with the court, and the court very categorically, it is one of the rare moments when religious matters have ended in the court, and it is such a peaceful argument from both sides, and court is really spending its quality time in giving the best judgment. And I'm very positive that this time it is going to be an unprecedented judgment. Two things definitely are going to happen. One, there is going to be a statement on the Wazu Khana, and one, there will be definitely cognitive action taken by the court on this matter, where the Shivling is placed. That will be a point of a very interesting point. Second, is also going to be there is going to be an absolute clarity on 1991 Worship Act. Now, we have been debating, the whole confrontation is about, was 1991 Hindu worship places for Worship Act, will it stand or not? Because if it doesn't, then Mathura is going to be the next case. Then something else is going to be the next case. But the point here is court has two important things to discuss. One, based on the report of Archaeological Survey, whether the Vazukhana, the shivling is there or not, and by the character of it, the court will give an announcement. I'm very confident that they will announce it is there or not, whether they confine it or whether they let Hindus also pray and worship the deity there or the shivling there. That has to be seen. I don't think they are going to be so extreme today. At least there will be a procedural setups or recommendations given by the court. But more importantly, there will be unearthing whether the 1991 Temples Act should be reconsidered, or the discussions around that should be opened up to public forums and the responsible media.
Absolutely, because that has been the crux of the argument in the case as well.
Absolutely.
But I will say, Asad Zamab, when a very important point that was raised by him is that it's gone on very peacefully. But if you look at, leave the statements that have come in from politicians aside, the petition that had been filed by the Masjid Committee as well had said that such a request from the Hindu petitioners could cause communal disharmony in the area. That is something that has been completely disproved, because as long as there is faith in courts, that's not going to happen. Here as well, as we have seen so far, it's been absolutely peaceful, as it should be, because what the Hindu petitioners have asked for is to just ensure that the truth comes out.
Yes.
The main fact is that every citizen of the country respect the court, whether it is the Supreme Court or the High Court or the local court. Every citizen of the country respect the lawyers, whatever the decision will come, everyone will accept that. Everything goes in a court is a very peaceful, very good harmony. They both shake the hands before the communication. After giving their versions, although they shake the hand, there is nothing you can say the dispute thing. But what the angle going in a society, that is somewhat the Hindu-Muslim angle. That is not to be taken like a Hindu-Muslim angle. It is to be taken like a property dispute. Two parties, they are giving their versions in front of the judiciary. One will be submitted, one will be
rejected.
Then
why exactly seek a complete dismissal of the petition, sir? The Muslim side has been doing that. They want a complete dismissal of the petition. Why then?
They want the complete dismissal of this case because they are going towards the Worship Act 1991.
Let the court decide, sir.
After the Babri Masjid, it has been decided that nothing will be going
no, sir.
to
no,
the
sir.
right side or left side.
In the Places of Worship Act, when it comes to the Babri Masjid dispute, it has been mentioned as a land dispute, sir. There was a special mention, rather, in the act itself. Mr. Naidu, can you corroborate that? Because it is wrong to draw a parallel with the case when the Babri Masjid case is concerned. That was a land dispute. This is what we are talking about, a right to worship.
Oh, absolutely. This is totally different. I mean, Babri Masjid categorically Honorable Supreme Court made in its judgment, and why it is so evidently clear is in the decision of the court has assigned, a higher proportion of land. By in case it was a land litigation, yes, the discussion and the debates were around the faith because Hindus believed it is the birthplace of Sri Ram Lalla, and Muslims believed that there was a mosque, and it has a very strong history back, about 40-50 years of history. But all putting aside, the Supreme Court, all in its true spirit, has made it clear that we are not going to do any kind of disparity. There is going to be, a reasonable amount of agreement, and the real estate, about 5 acres, has been given for a beautiful construction of a mosque, and that is how the issue has come to the rest. It was a very complex issue, but here it is a very simple, odd and even issue, or a black and white issue.
Absolutely, and that will be decided by court today. Thank you both for joining us on the broadcast.